Today we're going to be talking about the First Amendment. This is undoubtedly my favorite topic to cover in the whole class, so I cannot convey to you the level of disappointment I have that I'm making a video of this for you right now. It really won't capture just how awesome the First Amendment is and how much of being an American the First Amendment really defines. So we'll start out with just the language of it. The First Amendment states Congress shall make no laws respecting an establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for the redress of grievances. So it's a mouthful. There's a ton of stuff laid out in the First Amendment. Each one of those commas and colons indicates a specific clause that is legally protected. Each one of those clauses has dozens of court cases attached to it, tons of legal interpretation, and rules that have been laid down by the Supreme Court. So what I'm going to do is I'm going to go through them in the order they appear in the First Amendment. We'll talk about the special legal descriptions of them, and we will also look at some examples of how those laws act within the United States. So starting with religion. Religion is the first part of the First Amendment. It's also the most complex in that there's actually two clauses within the First Amendment devoted to it. Those two clauses are first, that Congress shall make no laws respecting the establishment of religion, and two, that it shall make no laws prohibiting the free exercise of religion. So those are two discrete legal concepts, and that means that they actually work independently of each other. The first part is what we now call the Establishment Clause. That's the clause that deals with the government not being able to establish religious entities. England had the Church of England that was headed by the king. The purpose of the Establishment Clause was to limit the ability of the state to create a legal entity that would be a religion attached to the state. So religions and states are separate entities in the United States because of the Establishment Clause. But also the issue has to do with preference. It also prohibited Congress from adopting a religion. So there's already a church out there, and a lot of people in Congress are members of it. And the Establishment Clause is there to say, just because you like that religion, or just because the majority of the population is of that religion, or the majority of the people in Congress are of that religion, or the president is of that religion, doesn't make it the official religion of the United States. That's the purpose of the Establishment Clause. There's a couple relevant cases, some of which you've been looking at. Engel versus Vattel, of course, is one of the foundational Establishment Clause cases, but there are also ones dealing with schools teaching religious classes within them, or having one particular religion that is the preference of a public school. Or sometimes it's public facilities like courthouses, post offices, government buildings, the Capitol, state capitals, having religious displays in them, such as in the McCreary County case. So the Establishment Clause is sometimes called the Separation Clause. It's where we get this idea that there's a separation between church and state. One of my favorite examples recently of the Establishment Clause is the Oklahoma State House Ten Commandments statue. So Oklahoma had a giant tablet of the Ten Commandments donated to it to be displayed on the State House grounds. The state representative who was behind the move to get it adopted said that it was because of the status of the Ten Commandments as a legal document, that it's a historical, legal entity. It's laying down the laws of the Israelis, in ancient Israel in biblical times, and that was kind of the pretense for it. But it's obviously it's tied to a very strong Judeo-Christian lineage of, religious law. So, the Satanic Temple, not to be confused with the Church of Satan, those are two different groups. Such is the nature of religion in the United States and its ability to radically diversify. The Satanic Temple built a giant bronze Baphomet statue with two children looking up to Baphomet lovingly, and they had that put on a truck bed and parked in front of the Oklahoma State House. Because they said if the state was going to adopt a religious symbol in the Ten Commandments, then it needed to either have no religious symbols on the state capital grounds, or it should make the state capital grounds free for all types of religious expression. And so they put their giant Baphomet statue there as a way to kind of highlight the Establishment Clause issue that the state of Oklahoma was perpetrating. Both were then voluntarily removed to avoid any further hurt feelings or entanglements between the state and religion. So one of the cases you guys looked at was Lemon versus Kurtzman back in 1971. The details of the case are kind of complex because it's a joint decision, so it's a couple cases, and then the courts said these are all similar enough, we're going to issue a ruling that covers all of them. But the outcome is the important part. In the Lemon test, the courts decided they had to stop taking these religious issues on a case-by-case basis and try to come up with like a guiding principle for religious issues. They settled on these three questions that every case about religious establishment would have to answer. So the first is, was the purpose of the law or action secular? So there's not a religious reason for that law to be passed. It's not performing some religious action. The whole goal of the law is to just be neutral. So if it isn't neutral, if it's not secular, then it fails the first part of the test, and it's obviously a violation of the Establishment Clause. The second part is it can't advance or inhibit religion, so you can't pass a law that's going to either purposely hold up a religious group, like elevate them above others, and you also can't pass a law that purposely targets a religious group. It needs to be religiously neutral. It can't help or hurt religious groups. It's one of the reasons why religions in the United States, churches are tax-exempt entities, because taxes could be very easily used to target some churches over other churches and display preference for them. And the last one's the trickiest one. It can't foster excessive entanglement of government and religion. This is another one of the reasons why churches aren't taxed, because it would require parts of the tax code to determine what was religious spending and what was not religious spending, and that would require the government to put a lot of time and effort into dissecting religious tax returns, and so instead they just don't do it, and therefore there's no excessive entanglement. Another recent case dealing with the Establishment Clause kind of signaled the modern courts' shift away from the Lemon test, and that was the American Legion versus the American Humanist Association. You actually looked at that case as well. In this case, there was a World War I memorial that was privately constructed. It's a giant 40-foot cross. Cross is a pretty obvious religious symbol, but it was adopted by the state of Maryland as a World War I memorial, and therefore the state was using funds to maintain it. It is getting on in years. It's a very large statue, and it does need maintenance to make sure it's safe to be around and that it's still standing as a monument to the soldiers that fought in the war. The American Humanist Association objected to the state spending taxpayer money to maintain a religious symbol, and that went to the Supreme Court, and the Supreme Court actually ruled that because the symbol was also a symbol of a war memorial and had very, historical and traditional status as a memorial, it was perfectly fine for the state to adopt it. So you can kind of see how they're shifting from a more straightforward understanding of how the Lemon test would look at establishment, where it's either religious or it's not, to a more nuanced way of looking at it, where certain historical and traditional and ceremonial actions, like one nation under God being in the Pledge of Allegiance, or Congress opening every year's session with a chaplain of some denomination saying some sort of blessing for the opening of Congress. Those are traditional actions, and so they can be allowed to persist. The Free Exercise Clause deals specifically with how government regulates religious practices. If you're doing something as part of your religion, the Free Exercise Clause is there to say your religious practices are protected. There is a limit, though. Practices that could be harmful can be regulated. So there are some Christian churches in the South and in Appalachia that practice snake charming as part of their ceremonies, and that can be very dangerous, especially since they're using poisonous snakes. And so the churches that were using poisonous snakes were told that they were not allowed to use poisonous snakes anymore because of the harm that could befall practitioners being bitten. The downside here is that forced them to practice underground in order to avoid prosecution, which does mean that you have more likelihood of people being injured rather than less. Wisconsin versus Yoder is a good example of the free exercise clause in practice. That was the case where Amish communities objected to children being forced to go to school through 12th grade, and so because they could, better serve their communities if they were, within the community working and helping support them. And the Supreme Court sided with the Amish community. It sided with the petitioner, saying that states could not force Amish children to attend secondary education beyond 8th grade. And if they could show that they had their own internal schools or were homeschooling, then they didn't have any obligation to send their children to public schools at all. That brings us to the freedom of speech. The freedom of speech also has lots of complexity within it. We've had an issue with free speech in the United States as long as there's been a United States. If you take a look at good old John Adams and some of the things that he did as president, he passed the Alien and Sedition Acts to arrest and deport non-citizens for promoting dangerous ideas from enemy countries. The horrible, dangerous country he was talking about was France. He was mad that French revolutionary thought was seeping into the United States. He was very disturbed, and a lot of the Founding Fathers were very disturbed about a lot of the violence of the French Revolution, except for Thomas Jefferson. He was all about it. Got to water that Liberty Tree with all the blood you can. It really needs it this time of year. So he passed the Alien and Sedition Acts through Congress so that he could deport the more radical French elements from the United States. He also then used it to find journalists who wrote mean things about him and arrest them and put them in jail. This was very unpopular, and it only led to the continuing unpopularity of John Adams. And when Thomas Jefferson became president, he had the act repealed, and one of the very first things he did was pardon the journalists that John Adams put in jail for saying nasty things about him. One of the cases you guys looked at on speech was the Schenck versus United States case. This one stems from World War I. Schenck was passing out pamphlets telling people to not participate in the war, burn their draft cards, and advocating anti-American sentiment during wartime. So he was arrested and charged with sedition. The Supreme Court, while it did not like to limit free speech, did come up with what they called the clear and present danger standard. Oliver Wendell Holmes coined the phrase clear and present danger for speech during wartime that could immediately pose a clear and present danger to public order and safety. And the example he gave was if you yelled fire in a crowded movie theater. People would panic, they would charge the exits, and someone could be injured, and your words caused those injuries indirectly. So that's how that standard was designed to function. The government basically said Schenck's speech was indirectly harming the United States' ability to fight in the war and legally harming people he told to break the law by not participating in the draft. Now, the Schenck case is one of the cases that the AP has targeted as one of the required ones. It confuses me a little bit because it does get superseded. The Brandenburg versus Ohio case that comes later actually kind of tones down the strength of the government to limit speech the way they did in Schenck. Even Holmes himself said that Congress basically took his idea and went wild with it and was too aggressive at curtailing speech. So the Brandenburg case replaced clear and present danger with the imminent threat rule. So even if you're saying something terrible, even if you're advocating against the United States, even if you are a bunch of, grandma's bedsheet wearing Klansmen, that speech is still protected. You have to be imminently inciting a specific threat. So if you say, let's go burn down a church, that's not protected speech anymore because you're inciting an imminent action that could cause harm and threat to public safety. So the Brandenburg v. Ohio ruling loosened restrictions on speech that Schenck had created. That brings us to speech that's not speech. Symbolic speech is actions that have messages conveyed within them. So you're not actually saying anything. A silent protest is still protected by free speech because even though you are silent and you're not actually speaking, you're conveying a message, and that's the thing that is protected. There's a couple cases that deal with symbolic speech. One of which you looked at, Tinker versus Des Moines, is about student free speech. The Tinkers were suspended for a Vietnam War protest of wearing black armbands with peace signs on them to school. That resulted in their suspension. And if you think your parents calling the office and complaining about your grades was hardcore, imagine if your parents complained so hard it made a United States Supreme Court precedent. That's pretty aggressive parenting. So the Tinkers case was actually overturned. They had their suspensions long after they graduated high school struck from their record, and that as long as student actions convey a political message and they are not disruptive to the educational environment, it is protected speech. So if you run into, had we been in my classroom, if you ran into my classroom to scream at me about how bad a teacher I am, that would not be protected speech because you were being really disruptive to my class. That's still something that's limited, but only in a school setting. Another example of a type of symbolic speech would be burning an American flag. I've mentioned before that there's a whole industry in Iran where they make American flags just so protesters can burn them. If you wanted to make American flags in the United States that were easier to burn, that would be protected, and that'd be an industry you could get into because there's lots of people who like to burn flags to send a message, and that message is perfectly protected by the Constitution. Texas versus Johnson, the Supreme Court said, burning a flag is the exact kind of speech that the Founding Fathers intended the First Amendment to protect. The last thing on speech, it's not a case you had to look at, but I figure I'd bring it up, deals with obscenity. Obscenity is not protected speech. The challenge is deciding what is obscene. The courts at one time actually looked at every single thing that was considered to be obscenity and made an individual decision about whether or not it was protected speech. And I think they probably just got grossed out eventually, and that's why they used Miller versus California to establish some general rules for obscenity. The first is that an average person applying their local community standards who looks at the work of art has to feel that it appeals to some sort of prurient interest. It's got to have something that is even vaguely acceptable or artistic about it in order to be protected. If it doesn't, then maybe it's obscenity. The second part gives us a little more detail. The work's got to describe or depict in an obviously offensive way some sort of sexual conduct or excretory function, which is a very legalistic way of saying bathroom humor is obscenity. Kind of have to agree there. And if the work as a whole must lack any kind of serious literary, artistic, political, or scientific value. So, obscenity tends to be something that's very subjective. The courts basically created a system that says, yes, it's very subjective, but if it can't fit into any of these categories, then maybe it's obscene, and then local governments can feel free to regulate it. Usually the location has a lot to do with obscenity. If you're in Times Square in the middle of New York City, billboards tend to be a little bit more racy, a little bit more risque, because you're in Times Square in the middle of New York City. If you put a giant billboard for underwear up next to an elementary school in rural Ohio, you would probably offend people. So, the local community standards are going to have a lot to do with if it's obscene or not. As far as the freedom of the press goes, the main thing with the freedom of the press is dealing with what we call prior restraint. Prior restraint is this principle that Journalism and the press should not have to get their publishing cleared by the government before they publish it. This is actually a principle that predates the United States. William Blackstone, the jurist and lord from Great Britain, actually penned it as one of the principles that British governance should uphold. That a freedom from censorship is a expression of the public will to understand and hold the government accountable. And so, if the government had the ability to, prevent the press from publishing stories that make it look bad, well, then you don't really have a free press, and then you don't have citizens who can actually judge the government fairly. So we've got a couple cases here. As far as the most prominent one of the ones you had to look at was New York Times versus the United States. This had to deal with the Pentagon Papers. The New York Times actually was able to get a hold of documents showing that the military had been purposely misleading the government and preventing them from informing the public as to how the Vietnam War was going. And so when those documents were discovered and the New York Times tried to confirm them with the government, obviously members of the government wanted to suppress that information and say that it would damage the war effort, damage national security, endanger soldiers, all legitimate arguments the government can make for information to be withheld. But in this case, the Supreme Court said that just because it's going to make the government look bad, that's not a good enough excuse to prevent the press from publishing it. So they went ahead and ran the stories. The other limitations on the press are really just civil limitations. Libel and slander are legal protections that you have against personal attack. If someone publishes something falsely about you designed to injure your character on purpose, that's the key defining character there, that it's on purpose. They are trying to take you down. That is libel. If they speak it, so they say it in public, they release a video, they slander you on Snapchat, that would be slanderous speech. And that's all defined in civil court, so you could sue somebody, but nobody's going to go to jail. They'll just have to write you a check and say that they're sorry. And the challenge here is you'd have to prove intent with libel and slander. It's not bad enough to just spread misinformation about somebody. You have to be spreading misinformation about them with the intent of damaging their character or their career. Getting down to the end here, the freedom of assembly allows for people to peacefully gather and protest. It's one of the fundamental rights we have as Americans, our ability to protest, our freedom to protest. You can associate with groups as part of the freedom of assembly, so you can join political groups, religious groups, economic groups. As long as those groups don't promote illegal activities. So if you join the mafia, I'm sorry, that one's not covered under the freedom of assembly. But you could join the American Communist Party, and that also brings us to our next example. You could join the American Nazi Party. Ugh, why would you want to do that? They always look so lame. And they're terrible haircuts and bad facial hair. There is a Supreme Court case that the Nazis have, the National Socialist Party of America versus the village of Skokie, Illinois, had to do with a white nationalist protest. In 1977, Frank Collin, that's the guy right there in front of all the microphones, wanted to have a march, a white supremacist march in Chicago, and the city of Chicago did not want to have a white supremacist march because they thought it would provoke violence. Really, they were just afraid people would murder the Nazis and that would happen on TV and that would look bad for the city of Chicago. So, the Nazis, not wanting to get murdered, decided to pick a sleepy town just outside of Chicago called Skokie that just happened to have a very large Jewish population and several people who were actual Holocaust survivors who had moved to the United States to try to settle down. So you can imagine the village's absolute abject horror when they get this application for a Nazi march through their town that would very much upset their community. So they got a court order to prevent the march from happening, but the Supreme Court said fear of violence or counter protest is not a justification for limiting an assembly. If a group wants to protest, the government of that community has to honor their protest and any counter protest that might occur. And that does mean that they'll have to, staff police officers, keep the protesters and counter protesters apart, try to stop violence from breaking out, but they can't limit people's speech. Now, if you're at an assembly that is peaceful, and people are saying, they're doing the chants, they're doing the hey, hey, ho, ho's, where you can easily rhyme literally anything, or hey, hey, ho, ho. Off-brand mac and cheese has got to go. It's just cheating at that point, really. Be more creative with your chants if you're going to go to a protest. That, unfortunately, does not limit your right to protest, but violence does. As soon as a assembly becomes violent, governments are within their right to disperse those assemblies for the safety of their communities. Law enforcement can provide oversight. They can also limit the days on which assemblies can occur. They can require you to file permits with the city so that they can appropriately prepare their police departments. You cannot have a peaceful protest on someone else's property. It has to be public property. You can't do it in someone else's yard, someone else's land. It's got to be on land that is community held, which is why so often they're in the middle of the road, because that is community land. The last one is the freedom to petition the government. You have an absolute right to contact your government officials and complain to them, and they have to just take it. It's part of the job. Just because you don't like people complaining at you doesn't mean you can run and hide from them. The only limits on the freedom of petition are that you can't harass government officials, you can't show up at their houses, you can't hang out where they're picking their kids up from school, you can't stalk them down the sidewalk and menace them. Anything that's going to create a safety concern would be an obvious example of you not practicing the petition to freedom correctly. Just in the last couple days, I got a headline here that our Senator Sherrod Brown closed his Washington, D.C. office because staff members from other offices tested positive for coronavirus. And so for the safety of his staff, he closed his office. It doesn't mean he's trying to avoid the public being able to contact him. He's pretty active on Twitter. His email and everything is available. You can call his office. It just means that for the time being, getting an in-person meeting with him or his staff is going to be limited. And that's not a violation of the freedom to petition. So that wraps up the First Amendment.